class, I haven't learned all of your names, so when I call on you, please remind me your name first before giving your answer in response to a question. Where we left off is looking at how the Supreme Court, at the end of the second millennium Common Era, the end of the 20th century, began to reinvigorate notions of state sovereignty, of the idea that the Constitution protects states from federal overreaching, and that the courts have an important role to play there. We saw previously that in the almost 6 decades following the New Deal legislation and the courts moving to uphold that, the court in not a single case concluded that Congress had overreached when it was trying to exercise its power to regulate commerce among the several states, or interstate commerce. However, starting in 1995, the court brings its federalism revival to the commerce power. Article 1, Section 8 of the Constitution, remember you saw, gives Congress the power to regulate commerce with foreign nations and among the several states and with Indian tribes. Well, what does that power allow Congress to actually do? What sorts of laws does it allow Congress to pass? The first case that we have to look at then today is United States versus Lopez. So 153 on the materials. Here, remember, the case started when a high school student took a gun to school. It was discovered, he was arrested, the state started to charge him, and then the federal government came in, and it said, no, we want to get in on this act. You violated the Gun-Free School Zones Act. That's a federal statute. What does that act say? What does it make illegal? What's the conduct that it prohibits, that Congress chose to regulate? Yes, and your name? Danny.
I believe it was that you cannot possess a firearm within 1,000 feet of the school.
Right, you cannot possess a firearm in a gun-free school zone, so on a school premise or within 1,000 feet. He clearly violated that. Texas said, oh good, one less case for us to prosecute. The federal government charged him, tried him, convicted him. His attorney appealed. And even though the court had not found an overreaching of Congress's commerce power in almost 60 years, the Fifth Circuit Court of Appeals, which includes Texas, concluded that this was unconstitutional. The federal government took it up to the United States Supreme Court, which granted a review and held that, in fact, yes, the provision of the Gun-Free School Zones Act, 922Q, that bans possession of firearms in or near meaning 1,000 feet of a school, is unconstitutional. It's not something that Congress's power to regulate interstate commerce allows it to do. So, the question is, why not? Why did a 5-member majority of the court say Congress just went too far here? Chief Justice Rehnquist starts his analysis by telling us that we start with first principles. When you see that, some scholars have suggested, you know immediately that things like precedent and text and history are going to go flying out the window. And indeed, Justice Rehnquist takes us back to the early 1800s, to Gibbons versus Ogden and Chief Justice John Marshall's articulation of the scope of Congress's power, that says, look, Congress can't regulate purely local things. It has to regulate things that are national in character or scope. So the question is, why isn't this regulation prohibiting possession of guns near schools anywhere in the nation, why isn't that within Congress's power? Well, the court doesn't completely dismiss precedent. It looks at it, and it says when we look at precedent, we see that Congress can exercise its Commerce Clause power to regulate 3 classes of activity, 3 types of things. What do the courts say those are? Yes?
One is channels of commerce, and the other instrumentalities. instrumentalities, events, and things, and activities involved in commerce.
Okay. So, and what was your name again?
Jessica.
Thank you, no problem. So, the first thing the court says is Congress's power to regulate commerce among the states embraces the power to regulate the use of the channels of interstate commerce. The second category, as Jessica told us, is Congress has the power to regulate instrumentalities of interstate commerce or persons or things in interstate commerce. And what's the precise formulation, the wording the court uses for the third category that Jessica alluded to? Yes?
Has to have a substantial effect on interstate commerce.
Okay, and your name again?
Christopher.
Thank you, Christopher. Right. Congress can regulate activities that substantially affect interstate commerce. So, summarizing precedent, the court says these are the three sorts of things Congress can do. What are channels of interstate commerce? What would that suggest? Yes?
Roads, rivers, highways, railways.
Okay. Yeah, the things through which or along which commerce travels or flows, right? The channels. So boats, bridges, roadways, water, airspace, right? Instrumentalities of interstate commerce would then mean what? Again, the court doesn't define these terms here. It just gives you citations to precedent. But what does that term suggest? If something is instrumental.
Cars, boats, airplanes, the things that are traveling along those channels.
And why would that be considered an instrumentality of interstate commerce?
It's something that's used to carry commerce out.
Yeah, it's used. It's instrumental. So the cars, the boats, the trains, the planes, the automobiles are all instrumentalities. They are things that you use to transport commerce interstate. Congress can regulate instrumentalities of interstate commerce, or they can regulate persons or things who or that are actually in interstate commerce themselves. So, this second category, you should probably think of it as sort of 2A and 2B, because there really are distinct sorts of activities that Congress can regulate here. And you don't want to forget that, because if Congress does limit itself to regulating things in interstate commerce, then that's just fine. We'll talk in a minute about why the court doesn't think this law, the Gun-Free School Zones Act, counts as a regulation of things in interstate commerce. Finally, and the category that will most concern us today, Congress can regulate activities that substantially affect interstate commerce. Now, cases the court cites, for example, this, are ones that have found, for example, that a local manufacturing plant can be regulated by Congress, because when we consider, say, manufacture of, or mining of coal, you see a substantial effect on interstate commerce. Or wheat. That's the Wickard versus Filburn case that we'll turn to in a few minutes to look at. So, first of all, why, and these aren't difficult questions necessarily, they may be painfully obvious, so play with me. Why doesn't the law, the challenge provision, section 922Q, count as a regulation of channels of interstate commerce? What's it regulating? Guns where? Right, guns around schools, right? So you've got just these fixed little plots, these irregular shapes, because schools aren't perfect circles, sitting all over the country, and it doesn't say anything about taking them from here or there. It's not about you can't take them on interstate highways. If that were all it said, right? If Congress said you can't transport guns across interstate highways, the court presumably would have upheld that as a regulation of the use of the actual channels through which interstate commerce flows. But it didn't do that, and so it can't be sustained under the first category that Congress has the power to regulate. Next, instrumentalities of, it says nothing about trucks or cars, right? It's just about possession of guns near schools. Why isn't it a regulation of things in interstate commerce? Yes, Alex?
Guns aren't crossing state lines, they're staying within one state area, they're not being traded.
Yeah, unlike some federal laws, nothing in the Gun-Free School Zones Act says the guns that are prohibited to be possessed near schools have to have moved in interstate commerce or be moving in interstate commerce. It can just be simple possession. You can live next door to the Smith & Wesson factory, get a gun from their showroom, and take it to your local high school and violate the act. There's nothing in the act that limits its reach that way. And so it's a broader regulation. It's not just regulating guns that are in interstate commerce, right? Justice Stevens' dissent said, well, guns are articles of commerce. The court says, well, yeah, they can be, but the statute doesn't require them to have been interstate, in interstate commerce. So we're not in the second category, and that means the fight here is all about whether possession of gun near schools, that's the activity that Congress regulated, is possession of guns near schools something that substantially affects interstate commerce? Now, in deciding that question, the court was not writing on a blank slate here, right? Remember, we have these earlier cases. During sort of the Great Depression and then the New Deal, when the federal government passed all sorts of economic recovery legislation, the court backed off of its earlier aggressive sort of period of judicial review when it was striking down lots of federal laws as improperly invading the domain of the states. And in cases like NLRB versus Jones and Laughlin Company, Darby Lumber, U.S. versus Darby Lumber, and Wickard versus Filburn, the court upholds all of these different economic regulations by Congress and says, sure, it may just be a local manufacturing company, but you can impose maximum hour laws, and you can make employers pay minimum wage laws because you have a substantial effect on interstate commerce, even if the factory itself isn't engaging in interstate commerce, even if the lumber is locally harvested and then processed at the facility. So the question is, does the possession of guns near schools come within the scope of these precedents? And the one that the federal government most relied on here is Wickard versus Filburn, which is described on pages 14 to 15 of the materials when you go on and you look at the Raich case. In the Raich opinion itself, the court comes and discusses Wickard versus Filburn. Wickard, remember, was a wartime case. This is a case where the federal government had prescribed regulations to try to stabilize prices. Right? There was a great deal of scarcity. People were being asked to recycle and to eat unpleasant meats that were organs of animals that you wouldn't normally necessarily be eating. The whole country was pulling together, but there was a lot of economic turmoil because of the vast size of our effort in this overseas World War II. Right? So they passed laws, they created boards that would pass regulations for prices to try to stabilize the economy so prices wouldn't spiral out of control. Here, they applied their regulations to Farmer Filburn. And Farmer Filburn was not a huge agribusiness type farmer. He wanted to raise wheat and use it on his own farm. He didn't claim that he was trying to sell his bushels of wheat at the market. What he wanted to do was, sure, grind up some for flour for the missus to bake bread with, but also to feed it to the animal, the livestock. Feed the various livestock on his farm. They eat wheat, so he wanted to use it as feed. And he said, look, I'm not selling this. I'm not in the market. You shouldn't think that what I am doing then affects the market. It doesn't have a substantial economic effect. Congress, therefore, can't use its commerce power to reach what I'm doing. And the court said, no, actually, Congress can do this. This is a permissible exercise of Congress's power to regulate interstate commerce. Why? You've got this one little farmer who is not selling his wheat, so why can Congress say you can't grow it, which is what they did? Yes, and your name?
Dustin. Because everybody started doing what this farmer would do, and that's what the market.
Okay. Yeah. So the idea is it would be myopic for us just to worry about the specific plaintiff, Farmer Filburn. We have to worry about what's going on in the country, and if everyone did it together, then we would, in fact, see a substantial effect on interstate commerce from this. Why?
I guess because why would you see an effect?
Yeah, if none of them are selling this.
Because if you have some people that are growing massive amounts of wheat to sell in the market, and then those people are like, well, look, I'll just remove myself from the market and grow for my family, and all of a sudden there's no more wheat on the market for massive, consumption, and then you have everybody. You could just have all the wheat farmers just saying, okay, well, I just pull myself out of the market and grow for my family, and then there's no more wheat.
Yeah, I mean, so if I can't make enough of a profit at it, why go to the trouble? Or, sort of a flip side problem, you might think, well, okay, if all of these people absent themselves from the market, they might not have been massive growers of wheat to begin with, but now all of a sudden none of them are buying on the market. And that's going to upset what happens with prices, right? Supply and demand are the factors that the market takes into account for prices. So what Wickard tells us is that we have to worry about the cumulative effects, not just Farmer Filburn, but what if lots of farmers did this? Everyone's similarly situated. So this is sometimes referred to as the aggregation principle. When we look to see, is something that Congress is trying to regulate, does it have substantial economic effect on interstate commerce? Well, we have to aggregate all the similar instances of conduct like that. And here, the court says this is, in fact, something that is of substantial economic effect, even though Farmer Filburn, who was the appellee because the government lost below and so they appealed, even though his own contribution to the demand for wheat may also be trivial by itself, that's not enough to remove him from the scope of a federal regulation where, as in this case, his contribution to demand for wheat, taken together with that of many others similarly situated, is far from trivial. So you aggregate everyone like that, and then you say, altogether, when we look at them, do we see a substantial effect on interstate commerce? And the court says yes, and it sustains this. Wickard, then, is the case that the government most relies on. It says, well, you don't just worry about Alfonso Lopez Jr. going to his little high school. You worry about every possible person who is possessing a gun close to a school. So, fine, you aggregate, but when you aggregate, you still have to find what? A substantial effect on interstate commerce. So the federal government made several arguments about why possessing guns near schools would have this kind of effect on interstate commerce. What sorts of arguments did they make? Yes, in your name?
You're saying that it could affect the economy as a result of like violent crime that could affect the economy. People might not want to live or travel to areas where the schools would be unsafe. And then also there's things like violent crime in itself can have like insurance issues and things like that would always affect the economy.
Okay. Yeah, so violent crime itself, the sorts of crimes that firearms facilitate, have their own costs that might affect insurance, that might be then part of an interstate market, right? Lots of insurance is bought and sold across state lines in today's interconnected economy. People might not be willing to travel. Businesses might not be willing to situate themselves because of this. And then what's the third sort of argument? Yes, in your name?
The idea that it would affect the educational experience and people might not be getting reaching educational attainment levels to have jobs and that would affect the market in that way.
Okay. Yeah, so there's an effect then. We look at guns, we look at guns in schools, we see that that can interfere with the educational process. People may drop out entirely, or they may not get as good an education, and altogether then we can see an effect on our national productivity, right? So we often talk about whether we're at a handicap in sort of a global market competition circumstance. Are we educating our citizens to participate in sort of today's economic markets in an adequate way. And this suggests that no, once you interfere with education enough, and guns have the potential to do that, then that is sufficient. In addition, one of the things you should note for the doctrine, even though the court strikes down the act here in Lopez, it doesn't disagree with the established rule, which is we don't have to decide if in fact there is a substantial effect on interstate commerce. What's the question the court has to answer when it's deciding whether one of these laws is constitutional? Yes, at the back here.
Dave,
Yeah, Dave.
whether Congress had a rational basis to make that decision?
Right. The question isn't, do we think there's a substantial effect on interstate commerce at the end of the day when we aggregate everything? It's, could Congress rationally have thought that there was a substantial effect on interstate commerce? Why would we have a rule like that? Why would we have a test that asks judges not to tell us what's your best understanding of the facts that you're confronting, but instead, what do you think Congress could have rationally believed? What kind of purpose does that serve? Yes?
My name's Jade. It's so that you can keep the separate branches of the government separate, and so the Supreme Court doesn't, or the courts don't end up legislating.
Okay, to some degree, you want to keep the courts from legislating. You want to keep them from doing what? What do we do with legislation? We establish policies for the country, right? We don't want the court to establish policies. Would they necessarily be establishing policy? I mean, if it's really the case that something doesn't have a substantial effect on interstate commerce, what's wrong with the court then saying, so we'll strike it down? Why do they have to give this sort of extra room and say, well, no, is there a rational basis? Even if we don't think there is, why could Congress have
They
thought?
want the federal government's powers infringing on those of the states.
Well, okay. Now, if you don't want the federal government's powers infringing on those of the states, that would seem that you actually want the court there as a backstop, right? You want them to be able to say, well, Congress may have thought this was okay, but we don't. We think you're intruding on the states. So you want something a little different, because that certainly supports the holding here, right? We're striking this down. We think Congress overreached, tried to grab more power than the Constitution actually gave it in Article 1, way back in 1787 when this thing got written. So instead, though, they don't reject this rule that we're going to look for a rational basis.
I was going to say that the Supreme Court is more concerned with the whole rather than the individual instance in terms of its effect on Congress's reach.
Okay. So they're concerned more with the whole set of activities that Congress is regulating?
Yeah, like the Supreme Court doesn't care about the individual parties when it gets up to their level. So maybe passing judgment on whether they thought this individual instance, if in this individual instance Congress was right or wrong, is unimportant. It's more important to decide whether or not Congress had a rational basis for it.
Okay, so they should look more systemically rather than focus on individual parties. Alex?
I was going to say because by being able to make their own judgment, they're essentially just subsuming the legislature's decisions for their own. And then if it's just a judgment call, it's not a question of constitutionality. It's just a question of the court thinks something different than Congress. So they don't necessarily need to make a constitutional argument. They would just be saying, well, we actually think your interpretation was wrong. By making it a constitutional issue of what they thought, they're sort of reserving a separate power to compare the legislative acts to the Constitution rather than merely substituting their own judgment for the legislature.
Okay, so if the court were just going to ask, is there a substantial effect that we see in our eyes, in our judgment, the suggestion is that would be asking for it to make a judgment call when Congress might reasonably think something else. And we might not have a reason to think that the courts are going to be better than Congress at making those kinds of judgment calls. When you have to ask sort of complicated questions about vast national economic systems, then maybe 9 judges in Washington aren't going to be as good as 535 legislators who can hold hearings, who aren't just limited to deciding the case that these 2 people brought before them, that can look at the landscape, both the legal landscape and the economic landscape. So it gives Congress a measure of leeway. It gives them room that their judgment calls will be accepted by the court. Given all that, and since the court embraces this idea, we're just looking, did Congress have a rational basis? Why don't they think these arguments are enough to give Congress that kind of rational basis to think possessing guns near schools has a substantial effect on interstate commerce? What's wrong with these arguments, the way the court sees them? Yes, your name.
Because it would, if they could regulate that in the schools, it would tip the balance too far towards, they could regulate basically anything. If they could regulate guns in schools and education based on that, everything affects education. Education is mandated by the states for the most part. So they can come in and take a state, run things, and this is how education should be because it affects education for the future. I think they come in and take something else for the state. It basically eliminates that federal-state balance.
Okay, so the worry is exactly that if Congress can do this, that if this effect, these effects on it, the educational environment for national productivity, or crime and people not wanting to travel, all of these sort of broad consequences, arguable consequences of possessing guns in your schools, then why couldn't you make similar chains of broad reasoning and let Congress regulate everything? So the court's judgment here, striking down the act, basically follows from the point of view that there has to be something that Congress can't do with the commerce power. The power to regulate commerce among the several states cannot be the power to pass any law we think is good. Why not? It's our national government. It represents all of the people in all of the states. Why does the court think that Congress can't have the power to pass whatever laws we think are good? Yes. And your name?
Oh, Becky. One of the things they discussed was that if states have the freedom to sort of choose their policies, then it allows for creative freedoms, and so they might actually come up with something better. So even though Congress may think something's good, the individual states may come up with different ways of thinking that other states may want to adopt, and then wouldn't have the freedom to do so if Congress had decided it would.
Okay, yeah, so that's the laboratories of federalism approach, the idea that states are little places where you can run experiments, you can figure out what works, what doesn't work, what's a good approach, what's a better approach. And if Congress could regulate everything, then states would lose their freedom to experiment and try different things. Some states don't prohibit possession of guns on or near schools, or at least don't criminally ban it the way that the federal law does. So that's sort of the underlying policy concern that informs the court's idea. Why do they think that that's actually something the Constitution tells us? Because remember, if they're going to strike down Congress's worked product, they have to point to something in the Constitution and say, here's the problem. Yeah.
Well, I think it's the 10th Amendment combined with the fact that they enumerated the principles of what they could do. And the fact that this is limited to commerce implies that you can't say everything related to commerce, or they would have just put that in the first place.
Okay, yeah, so the 10th Amendment that says powers not delegated to the federal government nor prohibited by the Constitution to the states are reserved to the states respectively or the people. That suggests that there are things not delegated to the federal government and that are reserved to the states. The idea that Article 1 enumerates a whole bunch of specific powers that the federal government gets suggests that there are things it doesn't get. There are powers it doesn't have. And that the power to pass whatever laws are good, or you think are useful, would mean everything else that comes after the Commerce Clause is unnecessary, because you'd already have that. So it's this, what some scholars have called non-infinity principle. It can't just be an all-purpose regulatory power. It's got to be limited in some fashion. Well, what about Wickard? Right? So here, Alfonso Lopez says, I'm just a high school kid with a gun. I didn't buy it. I didn't sell it. I didn't hold anyone up and take money from them. Right? This is simple possession near a school. He says that's like Farmer Filburn, who's just a simple farmer. He didn't sell the wheat. He wasn't trying to. He's not buying it in the market. It's just a regulation of simple growing. Why does the court think that it's different? Why doesn't it let Congress aggregate things here? I'll do the little mock confusion thing that Professor Lyon talked about. Basically, what they say, and this becomes clearer in subsequent cases, is that the difference is we don't think that this activity is economic. Possessing guns near a school is simple possession. There's nothing about exchange, right? There's nothing about buying, selling, trading. So this is just economic activity. There's nothing in the statute that limits it to guns that moved in or are moving in interstate commerce. I'll skip over, in the interest of time, the part about findings. Basically, Congress didn't make any detailed findings about what the effect on interstate commerce would be that they might think. So what the court does to distinguish Wickard is basically say, Wickard involved economic activity. The regulation of wheat prices in a market commodity. Here it's just possessing a gun, right? It's possession. So we're not going to let you aggregate when we're talking about non-economic, potentially violent criminal conduct. That's not what was at issue in Wickard. You can't get the aggregation principle. You can't take all of the people together because, again, it comes back again to that bottom concern. We don't want Congress to be able to do anything. It shouldn't be able to do everything we feel like. And in order to accept those arguments about the costs of crime or national productivity, we would have to pile inference upon inference. We'd have to take this chain of causation from you possessing a gun and other people possessing a gun and students being nervous at school and teachers being nervous and not learning well and then not being able to do well when they graduate and a firm not wanting to bring their company there, and you get further and further away from Lopez's possession of the gun. And they say, we can't allow Congress to have infinitely long chains of causation or causal inference to show an economic activity. There's got to be something short of that. So, first time in 58 years, the court strikes down a law saying it goes too far. You thought you were regulating commerce, but you overreached. You intruded in the state's area, as you mentioned, of traditional concern, education, right? We have some federal laws that deal with it, but usually they do it by offering states money if they will follow federal standards, right? That's what No Child Left Behind does. It doesn't directly say you have to have classroom size like this or test scores that look like this. It could have been a fluke. It could have just been a one-shot thing saying, oh yeah, by the way, we're still here looking with our watchful eye on you, Congress. Don't overreach. 5 years later, though, the court strikes down part of the Violence Against Women Act and suggests, no, we are here to stay, and we actually intend to play a serious role in making sure Congress doesn't overreach, doesn't step into these state areas in ways that the Constitution doesn't justify. So here, Christy Brancala was a college student in Virginia who was allegedly raped by a football player there, Antonio Morrison, who got ultimately a very mild discipline by the college. So she sued him under the Violence Against Women Act, which is in the United States Code, Title 42 of it, Section 13981, the so-called civil rights remedy, says people who are victims of gender-motivated acts of violence can sue the perpetrators for money damages. So she filed a lawsuit against Morrison and said, I want compensation. She ended up dropping out of her college because of the trauma of what he did to her, and then the school's not pursuing it. The state universities. Congress enacted VAWA, the Violence Against Women Act, after multiple years of hearings, multiple legislative reports, input from all of the states. When the case gets up to the Supreme Court, they're supported by an amicus brief filed by the attorneys general of 38 states saying this is a law that's within Congress's power. Why? Congress concludes crimes of violence motivated by gender have a substantial adverse effect on interstate commerce by deterring potential victims from traveling interstate, from engaging in employment in interstate business, and from transacting with business and in places involved in interstate commerce, by diminishing national productivity, increasing medical and other costs, right? We're talking about violent crimes, so there are physical consequences of these acts, unlike, say, possessing a gun, and decreasing the supply of and demand for interstate products. The Supreme Court, by the same 5-4 vote in Lopez, holds that that provision that lets you sue the perpetrators of gender-motivated acts of violence is not within the power to regulate interstate commerce. Why is VAWA not in Congress's commerce power? Well, once again, it's not actually regulating channels, roads, bridges, anything like that, not regulating instrumentalities. It's not regulating things or persons in interstate commerce. And so they say, look, why did Lopez strike down the ban on possessing guns? Because it was a regulation of non-economic criminal activity. It didn't have a jurisdictional element to limit it to cases where the gun actually was in interstate commerce or had some stronger connection. And you had this attenuated link. You had to build this sort of house that Jack built chain of reasoning before you could ever get to a conclusion that there really is a substantial effect on interstate commerce. So they say the law here has the same sorts of problems. The Violence Against Women Act is regulating gender-motivated violent crime. That's non-economic activity. It doesn't have a jurisdictional restriction. It doesn't say, well, people who cross state lines and committed these acts of violence can be sued. No, it's anyone who does it. Again, they say even though Congress made findings this time, that's not the end of the story. That doesn't mean we have to accept it here, because once again, if you looked at that conclusion, Congress's reasoning is the same reasoning method, the same chain of inferences that it used for the Gun-Free School Zones Act. And that would then let Congress reach any crime through this idea that, well, the effects cumulatively are going to be substantial. And so it could regulate crime, it could regulate family law, and other areas of traditional state regulation. So once again, the court's worried that it would give Congress an all-purpose power, and that in so doing, it would invade what states are doing. And then they wouldn't be able to try out different things, and we would lose the benefit of that process. The casebook suggests maybe that's not always a good or a bad thing, that we're losing experimentation when what we're talking about is sort of experimentation at the cost of people's civil rights, right? So Christy Brancala, she had this right under the statute to be free from gender-motivated violence. And the court's saying, oh no, federalism and the process of having states as laboratories means the federal government can't impose that on the states. It's not that the federal government can't do anything in these sorts of areas. So as I mentioned, No Child Left Behind gives states money to bribe them to do things the federal government wants. And if you don't do what the federal government wants, you don't get the money, right? The court still upholds that. We call it conditional spending. You put conditions on the grants to states. And the court says that's okay. So if Congress wanted to give money, so it taxes everyone, has money, parcels it out to states and says, if you adopt this cause of action, you can do that. Of course, the difference is, since the federal courts can only hear certain types of cases, if it's just a state law, gender-motivated criminal act like that, you probably can't get it in federal court. If it's a federal law, like the one that got struck down here, cases arising under federal law, as you learned in civil procedure in the fall, would be things you could hear in federal court. So even though you can get some of the effect by bribing states with conditional spending, you can't get out of state court. And that was one of the problems that Congress was worried about, was that there's bias in the state courts. 21 states submitted reports showing, yeah, we have bias against gender bias in our own state court systems. Question? Oh, okay, sorry. So they strike that down. So with Lopez and Morrison on the books saying Congress overreached its commerce power by trying to aggregate these things that weren't economic to regulate them, we see a suit get brought that goes up to the Supreme Court and gets decided under the name, Wickard aggregation didn't work here because it was non-economic violent criminal conduct. They say, we're not overruling Wickard, but you can't use it in that circumstance. So Raich, Gonzalez versus Raich, goes up to the Supreme Court. A law professor from BU, who's now at Georgetown, Randy Barnett, was the plaintiff's attorneys, at least at the Supreme Court level. And here, what you had was a conflict between the United States Controlled Substances Act that said you can't buy marijuana, sell marijuana, possess it with intent to distribute, or just possess it at all. And California law, the Compassionate Use Act, that says actually we're going to allow medical marijuana use in certain occasions. You have to have a doctor's prescription, so there are going to be various safeguards restricting who can have access. But sometimes you need this, California concluded. Sometimes using marijuana is the only way to treat either a disease or its symptoms, or to deal with things like the side effects of chemotherapy for cancer. And so Angel Raich and Diane Monson are using marijuana, but they're not buying it, they're not selling it, they're just growing a few plants of their own. It's not like they have a forest in their garage. And so they say Congress cannot reach this because this is non-economic activity, right? It's just our own personal growth and possession and use for medical reasons sanctioned by state law. They ask the courts to declare that Congress's power doesn't reach that far, that the Controlled Substances Act then can't criminalize their growth and possession and use of medical marijuana. 6-3, the court says no. The court says, actually, Congress can do this. So the 4 justices who dissented in Lopez, Stevens, Souter, Ginsburg, and Breyer, are joined now by 2 of the Lopez majority, Justice Scalia, who wrote a separate opinion that you saw, and Justice Kennedy, who just went along with Justice Stevens' opinion. So the question is, why? Why is it that this law is within Congress's power? What's the court's reasoning here? Why do they say this is something that Congress can bring within its commerce power? It uses the 3 categories, right, that Lopez tells us there are these 3 categories that Congress can regulate. Once again, we don't have a regulation of the use of channels. We don't have a regulation of instrumentalities of commerce, or even of things in interstate commerce, because this bans even completely local possession and use. So how do they bring it within the 3rd category?
I was confused. Was it something like, even though it's an illegal market, that people growing it on their own is the same thing as wheat farmers growing their own wheat and affecting the market? So even though it's an illegal market that we don't really recognize, it's still a market, and therefore Congress still has the right to regulate it, and people growing it on their own would affect the supply and demand of the market.
Okay. So yeah, so they do say if people were growing it on their own, if they weren't regulated by the federal law, the Controlled Substances Act, there would be this aggregate effect on the market, right? So the question is, why is it that leaving it unregulated would lead to a substantial effect on this illegal black market for marijuana? So what's the court's answer there? Because that's where the action is these days. When you get disputes about whether Congress can exercise its interstate commerce power to regulate certain things, you're pretty much going to be arguing about, are we in that 3rd substantial effects category? And so the question in part becomes, when can we lump the effects together? When can we not? Here, even assuming it's permissible to lump the effects together, Why does the court think that if Congress doesn't regulate it, we will see effects? Yeah.
So that at any instance, the marijuana could be put on the market and traded interstate.
Okay, right. So it's just a moment away from the interstate black market in marijuana. Your medical marijuana is just an instant away. So what's the idea here? What is the court saying? And it does this at a little more length. It says, well, we're dealing with commodities that are fungible. There is no difference between medical marijuana grown by Angel Rach at home and marijuana bought and sold interstate for recreational purposes. They're fungible. There is a big market, though, for marijuana, and there is a big interstate market for this commodity. And the court suggests, look, there's going to be difficulties in enforcement then, right? People could try to defend against federal prosecution by saying, oh, no, this is not for the market, this is for my personal use. Well, the plaintiff's answer was, we don't have just our claim that, well, we didn't buy it and we're just growing it and we're not selling it. They said it's not just that it's personal use. We have safeguards, right? We have California legal restrictions that carefully delineate the circumstances under which I can use this and spells out who gets to use marijuana for medical purposes. The court says, yeah, but that's not foolproof. It can be diverted from medical use into the black market, or at least Congress could rationally think that. They could worry about that and think that this could be a problem, and that's a rational judgment for Congress to reach, and therefore, they say, it is permissible for them to conclude that taken in the aggregate, there is a substantial effect on interstate commerce, which means it's within the Commerce Clause grant of power. Well, what about Lopez? What about Morrison? Those are the cases that the plaintiffs primarily relied on here. The court doesn't overrule them, even though Stevens was one of the dissenters in both of those cases. All four of the dissenters in both of those cases are now in the majority. They don't overrule them. Instead, they distinguish them. Why are those cases different? Because this will tell us something about sort of the reach of each of the lines of precedent. Yes, and your name?
Natalie. They say that unlike Lopez and Morrison, like this activity is economic, and they go into a whole spiel about
And what is economic, basically, in their view?
I mean, they say that it could, they're kind of broad in what they determine as economic, I think, but it's the production, distribution, and consumption of commodities.
Yeah, so any commodity, anything tangible, or possibly anything that is sometimes sold, right? Services, right? The production, the consumption, the distribution of commodities is economic. And so, therefore, the Controlled Substances Act, the federal law, it's regulating economic activity. We didn't let you lump things together. We didn't let you aggregate in Lopez and Morrison because it was non-economic activity. But here, it is. And the other difference that they point to is they say, look, Lopez and Morrison, the plaintiffs weren't trying to carve out certain applications from a valid law. There they argued that the law itself, the ban on possessing guns near schools, or the law authorizing civil suits against perpetrators of gender-motivated violence, the law itself, they said, is outside Congress's power. Here, the plaintiffs concede that Congress can generally regulate drugs. And they're trying to carve out and say, but you can't use your drug regulation, the Controlled Substances Act, to reach homegrown, local, non-bought, non-sold marijuana that's being used for medical purposes pursuant to state law authorization. They say that's very different. Since they do adopt this broad idea of what's economic, they say so we can still aggregate, and this risk about it flowing into the black market, which Congress is trying to stamp out, is enough of a justification for Congress to reach this here and to refuse to exempt it and to leave it within Congress's power. Does this mean that people like Angel Rach or just TSOL? That people who want to use medical marijuana are never going to have any recourse? That you'll never be able to use it to treat your symptoms of chemo?
If you can
Becky?
somehow make it not a fungible good, if there's a way of doing that, then they will have recourse.
Okay, so one possibility is technological. If there's a way to make medical marijuana non-fungible, to somehow perhaps limit it so that you have to take it with in conjunction with some other medical substance, that one you can only get through sort of a regular system of medicine, that might be one possibility. But if you can't change that technologically, does that mean you're forever hosed? No, the back, yeah.
They make a point about that they're not even going to discuss the medical necessity of marijuana. So if they could bring another case where they could argue about the medical necessity of using marijuana for those purposes, then perhaps.
One possibility is arguing a necessity defense, that we can meet a criminal law traditional defense of necessity, which we'll probably see a little later this spring in your crim course, that might allow you to use it when it's the only way to control horrible side effects of treatments. But even if you can't do that, the court also allows that there may be another way to go about this if you really want to use it.
You can challenge the government's classification of marijuana as a Schedule I drug and get it moved. If they challenge that successfully and get it moved in another category, there's going to be less stringent requirements about its use in medicine.
Yeah, so one thing is the laws in place already make a route, an administrative route, to challenge classifications. And that might allow you to be able to start using it for medical purposes under proper restrictions. And even if you don't win on that route, the court says there's always our fallback, which is what? Yes?
The legislative process is how we convince a new act.
Yeah, right? So if enough people are convinced that this is a good idea, that this is necessary to be humane, take it to the democratic process, get Congress to pass a law. Because even if administratively the government doesn't reclassify it through the Department of Justice, or the FDA doesn't find medical uses, our elected representatives can override that. They can make policy choices on our behalf. That's what the court says it doesn't want to do. It says it's not doing that here. It's only insisting on constitutional limits. And there is no constitutional limit, according to the majority in Raich, on what Congress tried to do here with this. Now, Justice O'Connor dissents. And she's joined by Justice Rehnquist, Chief Justice Rehnquist, and Justice Thomas. She says, look, there has been no proven problem that medical marijuana is being diverted in any significant degree to recreational uses. So that's not something that can be used to make this permissible. The majority's reasoning gives Congress incentives to pass broader regulations. If a specific narrow class of activity wouldn't have a substantial effect on interstate commerce, sweep it into a broader regulation. And then you'll find a substantial effect. And the majority refuses to carve out this class, the subclass that didn't have effects. They say this then interferes with that role that Becky was talking about states serving this valuable function as sites for us to experiment and figure out what policies work. It does invade areas of traditional state concern, criminal law, social policy. Those are mostly state concern. You look at federal law, they are largely things like crossing state lines to do X, because there the federalism aspect is clear. They suggest that there is this objective distinction between the uses of medical and recreational marijuana, even if the product is fungible, and that the court is taking too broad a view of what counts as economic regulation. So, what do you think? If we still accept, for sake of argument, Lopez and Morrison as correctly stating limits on Congress's interstate commerce power, does O'Connor or Stevens have the better view about Congress's power to reach wholly local, non-bought growing for medical marijuana, personal use? Whose arguments did you find more persuasive? That's one of the sorts of questions I'll ask you. Your final exam will not just ask you what happened. It's not just purely descriptive. It's evaluative, right? Is this a good idea or a bad idea? Is it a good interpretation of the Constitution or a bad interpretation of the Constitution? We've got a substantial disagreement. It's not that the court's unanimous in one view. So what do you think?
Well, I thought in the dissent, a point she brought up, a distinction with Wickard was that these are commercial farms that were being regulated in terms of their weed, as opposed to, this is not a commercial entity of any kind when we're talking about these patients.
Okay, right, this wasn't wheat being grown in a little window box to use as an herb along with basil. These were commercial wheat farmers. Angel Rach and Diane Monson are by no means conceivably commercial growers. Angel had what, 6 plants the DEA destroyed? Other thoughts, other reactions? Yes?
I think that O'Connor's more practical. I feel like the majority of things that rest within the extraction points are the fact that there's no proven problem of diversion. So I don't exactly agree with the theory that medical marijuana is an instant away from the interstate market.
Should the court insist that Congress have to come up with proof? Or more evidence?
Well, if we're going to say that they have a rational basis for passing a law, then I think that the court is right to ask for that.
Okay, so rational basis implies some deference to Congress's judgment, but it still suggests that it's reasoned, that it's rational, that they do have some reason to think that, some evidence. Yes?
Yeah, but I mean, with the weed case today, they're just saying, supposedly rationally it's going to have an effect on the market. They didn't have any economists, come in and say, oh, absolutely, this guy is going to affect this production price. And that's just sort of a rational inference that if somebody is growing this substance in relatively small quantities, or the aggregate could theoretically very plausibly be going across certain lines.
Okay, and so does that then suggest that, given our precedents, Stevens has the better view?
Yeah, I mean, that's my sort of opinion was that it isn't just, we can really kind of get it as a commodity issue versus the other cases where they took the other point of view was kind of really more broad, sort of abstract relationship to this commerce clause versus this is something that's definitely more tangible aspect of something you kind of see in economic function.
Okay, so touch the marijuana and it can be bought and passed around, bought and sold. You don't touch the gender-motivated violence or pass it around and buy it and sell it.
I think O'Connor has the right idea because I don't think that Congress could rationally perceive that the minimal amount of plants, whatever, 6 plants, would have a substantial effect on the market. The way I look at it as if I were to buy stock in the stock market with my limited amount of money that I have currently, that wouldn't change the stock price because I'm not substantially affecting the market in any way. So in that sense, I don't think that Congress could rationally say.
Okay, and let me take one last question at the back, or comment, sorry.
I was wondering with the aggregation, does it matter that this law is only California law? And do they aggregate just Californians, or are they still aggregating the nation?
Well, you could ask, so what is it that Congress is reaching, right? So the test is the regulated activity, does it have a substantial effect on interstate commerce? The way the majority, and Justice Stevens' opinion, answers the question is to say the regulated activity is all of this buying and selling and possessing with intent to distribute and simply possessing marijuana. So that includes California's and it includes everyone else's. The dissent wants to say, well, we shouldn't let Congress just decide that's what we should analyze. We should focus on if there's a subset that is meaningfully different. So the dissent would say, if you're in a state with medical marijuana laws and controls like California's, that's meaningfully different. So they would say, take any of the existing states. And I don't know that we had, at the time, any other states with comparable medical marijuana laws. So they would have said, still, just focus on states that do put these medical safeguards in place. Whether or not that's enough to take you out of seeing a substantial effect is sort of the bottom line question. So we'll pick up on Monday with a little bit further on Justice Thomas's dissent before we go to look at the enforcement power. Thanks a lot.